Welcome to Freedom FANatics, a production of the Freedom Advocacy Network. This show is every Tuesday at 6 p.m. and on YouTube and Facebook, and you can also find it on IGTV. Each week we discuss the latest fan content with authors and creators right here. My name is Sholan, and this week I'm joined by Alex, who is our digital content coordinator here at FAN, and Ben works on our fan justice team, which oversees most of FAN's legal work. Yeah, I'm happy to have you guys on the show today. And first up, we'll be looking at our latest explainer video, which FAN releases every Monday. And this week's explainer video is titled Rights or Riots, Why Your Property Rights Matter. So let's have a quick watch.
What are property rights and why do they matter? Put simply, property rights are a way of agreeing who has what rights to which property. Imagine that you own a house in a society which does not have formal property rights. In such a society, you'd always have to stay close to your house to defend it, or else somebody could come along and simply take over your house or demolish it. You can't stop them by saying, "That's my property," because it won't really be. In contrast, a formal property right makes it clear that you are the owner of the house and that nobody may interfere with it without your permission, even when you are away. But clearly, property rights alone are not enough for you to control your property. You need someone to have your back when it comes to property rights. In most countries, this is the state. The state protects your property rights in three ways: through laws that establish the rules, courts that interpret and apply those rules, and police that protect your property, for example, when it is threatened by thieves, looters, or rioters. Individual property rights are vital because they form the foundation of personal freedom. They allow you to work for and earn wealth and protect yourself against economic risk and those who mean you harm, including the state itself. They are essential for building prosperous societies because they let you keep ownership of your property even when you're not near it. They allow you to change and improve it, sell it, and use it as collateral if you want to borrow money. Make no mistake, property rights are human rights. Protecting them is one of the most important functions of the state. You must ensure that your state protects your property rights and not undermine them.
Yeah, so we just watched our latest explainer video, and this week's one focused on property rights. Alex, I'd like to come to you first on this. And Alex, when we discuss property rights and the threats to it, such as expropriation without compensation, for example, something that a lot of people miss is the fact that the term property is not only limited to some piece of land that exists in the Northern Cape somewhere.
Yeah, 100%. It ranges from your cell phone to your house to your factory. It really does incorporate anything that sort of belongs to you. And obviously, in the video, we refer to formal property rights and make a sort of an allusion to a signed document. But obviously, there's informal ways of assuring that something does belong to you. And so, as we point out in the video, it really is a foundation to personal freedom. And so I think, the argument that needs to be made in order to defend it sort of makes itself, because without owning and having the respect of the people around you to respect what you own and vice versa is pretty fundamental to a functioning and prosperous society.
Yeah, and that's actually a great segue actually to bring in Ben here, because Ben, something that I'm really rather concerned about. I'm not sure if that's a good word to use, but it's the fact that many of South Africa's people are poor. Many don't own title deeds, don't have savings, don't even have sophisticated things like assets. What do we say to those South Africans who do not really have property of any sort? How do we tell them that property rights is actually important?
Well, I think the crux of that is that in order to get more people empowered, the answer is not to take away property rights; it's to enhance it, it's to expand it. when you own property, you're more likely to take care of it and take pride in it and feel empowered by it. Whereas if you live on state land or in a state house, or something's not owned by you, you're less likely to look after it and take pride in it. And I think it's all about empowerment, and property rights can really empower an individual and help them raise their standards of living and their lifestyle. So that is what I would say to that.
Yeah, okay, perfect. Thank you guys for your thoughts on our recent explainer video. And to our viewers, do not forget to watch our explainer videos, which are released every Monday, and it can be found on all our social media platforms. You can find it on our YouTube page, Freedom Advocacy Network. You can go find it on our Facebook, on IGTV. And you can also follow us on Twitter, Instagram, and on TikTok at Badger of Liberty, where we release it as well. So up next is our article of the week, which was actually written by Ben. And in it, Ben identifies 3 watershed legal judgments that were rather quite important. So Ben, what are these 3 legal judgments that you identify in your article?
Yes, so it starts off in about the 1950s. Sort of start of apartheid, and this is when things sort of started to go downhill. And it was encapsulated in the colored voters cases, which was a trio of cases. And the litigants, the names of the cases aren't really that important because they were just used as sort of vehicles to challenge this legislation. But basically, in the Cape Colony, everyone could vote in about 1910. Then in about 1936, black people were removed from the vote, but colored people remained on the vote, or colored men rather. And when the National Party came to power in 1948, they wanted to change that because the Cape Colony was not really a majority party for the MP. Jan Smuts was quite big in the Cape Colony. So what they did is they wanted to change basically the constitution of their time, and in order to do that, they needed a 2/3 majority, which they didn't have. So they passed a couple of acts to ensure that they had a 2/3 majority. They packed the Senate, which was one of the houses of Parliament back in the day, and then they also packed the appellate division, which was sort of the highest court back in the day. So even if it was challenged that the legislation of packing the Senate, the judges would just rule in their favor. So this created an ideology which underpinned apartheid, which was called parliamentary sovereignty. Basically, the legislature had almost supreme power. And this was very, very concerning, and it resulted in many of the racist laws that followed. So that was sort of the apartheid case. And then we have my second case that I identified, which was the certification of the Constitution. So we jump forward 30 years. We've been through a terrible time. And finally, there's been some negotiations with all the interested parties in CODESA 1 and CODESA 2. And finally, we've sort of come to some sort of an agreement. The interim constitution's been passed. And now they're sitting in the Constitutional Court for the first time. And they're going through the Constitution and they're certifying it. And Justice Arthur Chaskalson, who was the president at that time, sort of said, I'm not so sure about the independence of some of the Chapter 9 institutions like the Public Protector and so forth. And he was also a bit concerned about provincial autonomy. So they sent it back, renegotiated, and they finally came to the final constitution, which we have today, and is a fantastic document which we need to protect. And in my article, I outlined all the founding provisions which our constitution is based on. And then finally, we jump forward sort of 20 or so years into democracy to Agri SA, which was in 2013. And this is a very important case if we want to understand expropriation without compensation. So basically, in this case, there was a mining company called Sebenza, and they lost control of an unused mining right, and the state basically took control of it. And that unused mining right cost R1 million. So they wanted to claim compensation for it. And it went to the Pretoria High Court, and the Pretoria High Court said, yes, you can claim compensation for this. However, it went on appeal to the Constitutional Court. And our Chief Justice, Mogoeng, he was recently appointed at the time of this judgment by Jacob Zuma. He took a different line of argument. He said, no, the state hasn't expropriated this mining right. It has taken custodianship of it, hasn't taken ownership of it. In order for something to be expropriation, you must take ownership of it. The state's merely looking after it on behalf of the population. Therefore, it's not expropriation, and there's no compensation that needs to be paid. And this has sort of, in light of all the expropriation bills that have tried to be passed over the last couple of years, this has really been a grave area of concern. And Dr. Anthea Jeffrey, our esteemed head of policy research at the IRR, has done a lot of work on this, and she says that the sort of definition of custodianship that Mogoeng uses in this judgment aligns with the expropriation bill that's currently making its way through Parliament. So to sum up, these three cases span over 65 years of South Africa and sort of really give us a little bit of an idea into each sort of dispensation. So yeah, those are my three judgments that I spoke about.
Yeah, that's quite informative, I have to be honest, because I actually, someone who's quite a fan of Mogoeng, I must say I'm rather surprised at his decision-making with regards to expropriation without compensation. Yeah, Alex, do you have any final thoughts, like any one of those that just like a highlight for you?
Yeah, I think what sticks out is how important legal cases are in terms of setting a precedent. And I guess it's really cool that, you know, as Ben says, watershed cases. I think the final one is a great one to mention in that just before COVID struck, one of the big things that the ANC tried to push through was I believe in the sort of alteration of Section 25, which sort of relates to expropriation of the Bill of Rights, is they wanted to circumvent the courts as a mediator for negotiating the expropriation process. And that was pushed back heavily by civil society and opposition parties, barring the EFF. And, you know, 'cause now what's happening in this process is the ANC and sort of other left-wing parties are trying to push through the back door custodial takings to sort of weave their way around the whole thing of ownership. And so, you know, if you think that how we highlight the importance of property rights and private ownership in the explainer video, and we can see why the state really wants to take a private ownership away, because it is that important. And we've just got to think, well, in whose best interest is it that the state looks after your property? Yeah, it's a scary thought. So definitely a right and something worth protecting for sure.
Yeah, Alex, Ben, that was a brilliant discussion. Thank you guys for that. And our viewers, do not forget to catch us every Tuesday at 6 p.m. on YouTube and Facebook. And to join FAN, you can sign up at freedomadvocacy.net. And remember that your freedom is worth fighting for.